So thank you so much, everyone, for coming. I hope folks were able to get some food, and for people who aren't Kirkland folks, the restrooms are right outside. So usually I'm a jump in and ask questions whenever you want presenter, but because we're recording, I think that's going to just complicate things a little bit. So I think we'll just power through and then leave plenty of time for questions at the end. So I'm Abigail Trillin. I am the Director of Legal Services for Children, and Nicole Bates, our education advocate, is with me also. She's going to jump in and help me out. Nicole does a lot of our education work right now. And I really appreciate everyone being here and being open to being on our pro bono panel and taking these cases. I really want to stress that these are really, really impactful cases in terms of having pro bono representation. Of course, a major impact is that with pro bono representation, we win a lot of the time, and that's clearly a big deal, and we're going to talk a little bit more about why it's such a big deal and what the consequences of expulsion and exclusion from school are. But I think even in the cases we lose, and we do sometimes lose, it's a really big deal to have representation. And I think it's that's for a couple of reasons. One is just the importance for our clients at having their story told. It really, really matters when young people feel like their side of the story is getting across, even if ultimately that doesn't carry the day. We had a case recently that was just a really, really challenging case and really challenging hearing, and afterwards I just checked in with our client. I said, "How are you doing?" And I was really worried because, frankly, it just hadn't gone that well. It was a really hard case. And he said, "I really liked it when you guys were talking." And I think it's really, just for him having an advocate and having someone up there to try to let the decision makers know that he is more than what happened on that day, right? That he is a complicated person, and I think that piece is really, really important. The other thing is that I think that this is particularly true for teenagers, that just having a fair process makes a huge difference. I don't know how many of you spend a lot of time with teenagers. I have 2 in my home. So I will tell you for sure that fairness is a pretty major concept. And if things aren't fair, if an institution does not seem fair, that's it. They're done, right? And so I think what we've seen in some of our cases is, even if we ultimately don't get the result we want, if it feels like the process was fair, that the young person was heard, that at least whatever the result is somewhat within the realm of reasonable, then the young person is able to go ahead and go through the period of expulsion or whatever it is and go back to school and engage. Young people who don't have that feeling at all, who feel like they were really just shoved through the system, that they didn't have representation, that they're really kind of railroaded, both the young person and their family tend to really disengage and lose trust with school, and it's much, much harder for those young people to re-engage and get back to school. So that is just all to say that having your help on these cases is a really big deal. There's no right to representation in expulsion cases. This is all happens just based on nonprofits and pro bono representation, and it really, really makes a huge difference. So thank you for being here, and we really appreciate it. The other thing I just wanted to say before we get started is that no one should feel like what you learn here today is 100% of what you're going to have before you get started on a case. We have a very comprehensive manual on school expulsions that is on our website that we'll provide to you. Additionally, if you take a pro bono case with Legal Services for Children, you are assigned a mentor attorney, and the first step will be a phone call with that mentor attorney to really talk through kind of what are the steps and what's the how to proceed, and then the mentor attorney is available throughout the entire case. So you will not be left on your own as soon as this training is over to jump in on a case. There is a lot of support for you during the case. So, all right. So I wanted to talk a little bit about just what is the harm? Why are we trying so hard to prevent suspensions and expulsions? So let's see. We actually are going to just start briefly with video. Have a very short video that I think does a good job of really showing.
Increasing, even though juvenile crime rates have now been the school-to-prison pipeline. It's shorthand for how schools are funneling students, especially black students, into the criminal justice system. It started in the 90s when schools responded to fears about crime with zero-tolerance policies, which mandated suspensions and expulsions for certain violations. They also cracked down on little things like talking back or uniform violations.
I'm sorry, just give us 1 second to get the screen a little bit bigger for you.
That's pretty big.
Violations. The hope was that it would keep big might hear in the news sometimes, the school-to-prison pipeline. It's shorthand for how schools are funneling students, especially black students, into the criminal justice system. It started in the 90s when schools responded to fears about crime with zero-tolerance policies, which mandated suspensions and expulsions for certain violations. They also cracked down on little things like talking back or uniform violations. The hope was that it would keep bigger problems from bubbling up. But as a result, out-of-school suspensions have doubled since the 1970s, and they keep increasing even though juvenile crime rates have now been dropping for years. Around the same time, the number of police officers stationed full-time inside schools has increased by a third between 1997 and 2007. Ostensibly, they were there to prevent mass school shootings like the one at Columbine, but they end up being a way for schools to basically outsource discipline to the police. Schools with officers have 5 times as many arrests for disorderly conduct as schools without them. Sometimes the results are shocking. But the less visible effect is that schools are feeding the racial disparities in the criminal justice system. Consider the fact that schools are more likely to have an officer on their campus if the student population is more than 50% black. You might assume that that's because there's more crime at these schools, but although students at police schools are more likely to be arrested, they're not actually more likely to be charged in court for weapons, drugs, alcohol, or assault, at least according to one study. During the 2010-2011 school year, 1 in 6 public school students in the US were black, but they accounted for 1 in 3 arrests at school. Same goes for other forms of school discipline. Black students are suspended or expelled 3 times more frequently than white students. It actually begins in preschool. 18% of preschoolers are black. But if all preschoolers suspended more than once, 48% are black. Studies show that differences in behavior can't fully account for these disparities. Black students and white students are sent to the principal's office at similar rates, but black students are more likely to end up with a serious punishment. One study found that white students are more likely to be suspended for provable offenses like smoking or vandalism. Black students are more likely to be suspended for subjective offenses like talking back or insubordination. Students who are suspended in school are more likely to later drop out or get arrested, so the federal government is asking schools to make suspension and expulsion the absolute last resort. In Oakland, California, public schools are trying something called restorative justice, where both parties in a conflict talk it out with a counselor instead of relying on punishment. The results are pretty encouraging. In the last 10 years, chronic absenteeism is down, and graduation rates are up in the schools that have tried it. Other cities and districts are also trying new policies. They're hoping that if their students end up in the criminal justice system, at least it won't be because the schools pushed them there.
That very last piece where it talks about the restorative justice work that's happening in Oakland and some other districts is kind of another additional benefit to doing this work is that it pushes districts to look at alternatives. I think most districts would like to look at alternatives to school exclusion. They would like to look at restorative justice, but there's a lot else on their plate, right? There's a lot going on in a busy school district. So they're less likely to do that unless there's some pressure for that to happen, and that could come from community pressure, but it also sometimes comes from people who make expulsions kind of a pain, as in lawyers, right? So we actually recently had a meeting with the lawyers for a couple school districts in a county where we'd been pretty active lately, and they suddenly wanted to talk to us about what Oakland and San Francisco are doing around restorative justice, and could they maybe convince their clients to look at that. And so it really matters, right, to both in the individual cases, but actually the work that you're doing representing students in school expulsions could have an even bigger impact in terms of really pushing districts to really look at alternatives that might really make a huge change in the way discipline is handled. So this is some data from the most recent data that we have. in terms of school expulsions and just looking at different counties. I think that the expulsions are in red. I think what is interesting is that you see some very large numbers in counties that are pretty small counties. So like Solano County has almost 100 expulsions. It's a small county. San Francisco has 4, right? And let's see, where's San Mateo? Oh, San Mateo also, that's a lot of expulsions for a pretty small county. And so you're seeing different counties represented at a different rate. And I think a lot of that does have to do with the restorative justice practices that some districts are implementing. So things that, the reasons why suspensions and expulsions are harmful, there's no research whatsoever that shows that they improve student behavior. In fact, they often exacerbate it, which, is sort of logical if you think about it, right? I mean, it doesn't, probably is not super inspiring to not behave. If you're having trouble in school and you get sent home, obviously the students lose valuable instruction time, and so often students who are being disciplined are the ones who are already behind, makes them more likely to miss a grade, more likely to be suspended again, and really more likely ultimately to drop out and to disengage. And this happens even at a young age, even when you have kids who are being suspended in 4th, 5th grade, it just starts to change the way they think about themselves and the way they think about themselves in relationship to school. And so they might suddenly think, yeah, this obviously is not my place because I keep getting sent home, right? So it really matters in sort of how they perceive themselves. And of course, as the video talked about, ultimately are more likely to enter the juvenile justice system. As the video talked about, this is hugely racially disproportionate in terms of how it's impacting students of color, Black and Latino students. And so this is exacerbating all the existing disproportionality in the juvenile justice system and in issues like dropout. The other thing I think that's really important to understand about school discipline is it's very connected to trauma. So a lot of the behaviors that tend to get kids in trouble in school are behaviors that are common to see in children and young people who have experienced trauma. And so, again, we're talking about students who are already most vulnerable, right, because they've experienced significant trauma. They're already kind of coming to school with some significant challenges, and then they tend to get in trouble for things that, like acting out and impulsivity and things that are often the result of the effect that the trauma has had on them and on their development. And so, again, we're seeing a disproportionate impact on those children. ACEs stands for Adverse Childhood Experience. That's a lot of times how we kind of calculate or look at trauma. It comes from a Kaiser study. And so children with 3 or more adverse childhood experiences, which are things like death, neglect, community violence, have very, very significant disparate results in terms of their behavior issues in school and their likeliness to be suspended or expelled. So again, it's impacting an already really vulnerable group of children. So in California, the law that you base your case on, your representation, comes from both California and federal law. There is a fundamental right to education in California, and it's actually stronger in California than in a lot of other states because it's in our state constitution, in addition to the federal protections. Based on a Supreme Court case that hopefully folks remember from law school, you do have the right to challenge punishment before you're removed from school. That comes from the Gospi-Lopez case. And there's a number of cases that came after that in California that reinforced that and that ultimately kind of, impacted the way that the education code was created. There's not a lot of cases, just to put that out there. So if you think that you're about to dive into a whole new area of law where there will be, cases and cases to research, that's not going to happen. There are very few cases on this topic, partly because a lot of these cases don't get challenged because the students being expelled are less likely to have representation, and partly because even when they do get challenged, they tend to get mooted out pretty quickly. So there's just not a lot out there in the case law, but there are a few. You can find them in our manual. And the most important thing to be aware of when you're looking at these cases is what's in the education code, and that's all spelled out in our manual. But the education code section on school discipline is about 10 pages. It's not long. You can become a school discipline expert very, very quickly, and very quickly you'll actually know more than some of the folks that you're dealing with, be able to say, oh, actually, here's what we need to do in this hearing. So it's not hard to get up to speed. So in school discipline, we start with kind of general discipline. That could be detention, things like that, loss of privileges. We then get to suspension. Suspension is significant because it involves removal from school. A suspension is a temporary removal from school. Most suspensions are between 1 and 5 days. The exception is something called an extended suspension. An extended suspension is a suspension that goes after the 5 days because an expulsion hearing is pending. It's called an extended suspension for that reason. An expulsion is by far the most severe form of school discipline. It's a removal of the student from all the schools in the district, so not just from the school that they're at. And it can be up to 1 calendar year depending on the offense. So it's very long term, and it's very significant because it actually removes the student from all comprehensive schools. Fortunately, all students still have the right to attend school. So even if you are expelled, the district is required to place you, but often you're placed in like a county community program or some kind of alternative program. So not the regular high school or regular middle school. Suspensions, as I said, can only be 5 days, except for the extended suspension. You do have the opportunity to be heard. It's pretty basic, right? You have the opportunity for basic notice and opportunity to be heard. One really unfortunate thing is there's no right to education during suspension. So even though some districts will set up kind of a counseling center, that's actually not required by law. It's not even required that they give you your homework, even though, many teachers will, but it's actually not required by law, which is not good. So there is a long list in 48900 of grounds for suspension and expulsion. They're the same with one exception. So these are kind of some of the biggies: causing physical injury, weapon possession, drug sales, theft, possession of drugs, or drug paraphernalia. But the list goes on a bit. But you cannot be suspended for anything that's not on that list, and you specifically can't be suspended or expelled for absences or tardiness. Kind of makes sense. Like if the issue is you're not going to school, suspending you from school is not the greatest solution. So, but it actually says that in the Ed Code, and it's actually really helpful. For example, we've had some questions come up recently around all the walkouts that are planned, actually tomorrow, and whether students can get suspended for them. The answer is actually no, because while you can't be specifically punished for free speech, you could be punished for leaving school when you're supposed to be in school, but it can't be a suspension because that would be a suspension for truancy. So it's not that you can't get in trouble, but the punishment can't be a suspension. We've historically had something on that list, long list, called willful defiance, which is pretty much defined as anything. And so there's been a really great push throughout the state to curb the reliance on that and limit it. There's legislation pending right now around its use in suspensions, but it is no longer a ground for expulsion in California. So that's the one explicit difference between the long laundry list for which you can be suspended and the list for which you can be expelled. And right now you can't be suspended for if you are in below less than 10 basically, or 9, which is kind of ridiculous. However, a number of school districts, San Francisco, Oakland, Los Angeles, do not suspend at all anymore for willful defiance. And you can imagine, because that's so broad, it also has a more significant disproportionate impact. So anytime something like that is just so vague, it is going to tend to kind of bring out folks' implicit bias. So that's one of the reasons why San Francisco and Oakland and LA just took it out for their district. Because you're allowed as a district to be more protective for students. You can't be less protective than state law, but you can be more. So let's just talk quickly about the suspension process. Generally, this is going to happen before you all get a case. it tends to happen immediately, and so kids are going to go through this process without representation. But after there's an incident or an alleged incident, the principal is supposed to hold an informal conference with the student, and that is supposed to be the basic notice and opportunity to be heard. So it's just like, here's what's happening, here's why you're being suspended, and a chance for the young person to tell their side of the story. There is an exception for that if the student causes a clear or present danger, in which case they can hold it at another time within 2 days. They are also supposed to call the parents. They are also supposed to send a letter to the parents and also report a suspension to the school board. This part's important because actually when I first started practicing here, had just been this recent big initiative by the school superintendent to reduce suspensions. And then I started getting all these calls about kids who were told just to go home and like, don't worry about it, we're not going to put it on their record. And basically that was an attempt by the schools to keep doing what they were doing without getting in trouble with the superintendent. And so you actually, even though that sounds like a good thing as a parent that's not going to go on the record, it's actually a bad thing because it means there's no accountability for the school. So that's not legal. You can't get sent home unless you actually were suspended. Parents are invited to come to a conference when a student is suspended, or they can be, but the student's return to school absolutely cannot be dependent on them doing that. And that's really important. That is explicitly written out in the Ed Code. It's really important because a lot of kids have parents who can't make it to conferences, either because of their work schedule or because of illness or because they're not around. So it is absolutely not legal for a school to say, you're suspended until you come back with your parent. And unfortunately, we hear about that happening, but it's not legal. The suspension notice has to have a number of days, and in that number of days, you come back. If a student is pending an expulsion, you can have this extended suspension, but it's actually a new meeting. So it's not legal on that very first day that you get in trouble to get a notice that says you are suspended until your expulsion hearing. You can only be suspended on that initial day for the 5 days, and then on that 5th day, they have to have another bit of due process, still a very small bit, but you have a right to have a meeting. The parents have to be invited to really determine whether this extended suspension is necessary. Because even though some schools might act like if you're going to have an expulsion hearing, of course you're going to be suspended until that time, that's actually not what the law says. The law says you should only be suspended from day number 5 of suspension until the expulsion hearing if your presence would cause a danger to persons or property. Or a threat of disrupting the instructional process, which is obviously a little bit on the vague side. But
I would just add that if you do get a case before this extension of suspension, meaning it is a great way to go and advocate. They're not used to having lawyers in the room. They're used to just telling parents like, oh, your child is a danger. So it's actually a really good opportunity for you to make the district articulate why this child is a danger, especially given whatever the offenses are. So I would just add that bit.
Absolutely. It's so fantastic if you can get them not to extend the suspension. Number one, your client won't miss all that school. Number two, it becomes so much harder for the district to argue at the expulsion hearing that expulsion is necessary if they've been in school and doing fine and nothing else has happened. So if you can get that to go away, that makes a huge difference. So yeah. So expulsion, being the removal of students from all the comprehensive schools, is obviously a really big deal. Generally, students end up in community day schools that are run by the county, where the other students there have also been expelled. So there's a lot of disadvantages to that kind of placement. Very, very important that expulsions, and we'll go through this in detail, can only be ordered by the governing board. So it's a step, there's several steps that have to happen. I have had so many times a student or their parents call me and say, I was expelled. And then you ask them what happened, and it's something that happened 3 days ago at their high school. But the impression that they have gotten from their principal is that they are already expelled, and it's a done deal. That is not true. The only thing a school site can do, the principal can do, is recommend expulsion. Then you have a right to a hearing, and the only entity that can actually expel you is the school board. So that's really, really important in terms of process. So the process starts with whatever the initial incident or alleged incident is. And then you have to have that extension of suspension meeting, which again is a great opportunity to advocate. There is another step for students with disabilities. If the client that you're working with has an identified disability and is receiving either what's called an IEP, an individualized education plan, or a 504 plan, which is about reasonable accommodations. It's sort of less detailed usually than an IEP, but it's still accommodations. They are entitled to a meeting before you even go forward with the expulsion to determine whether the incident or the behavior was related to their disability or was related to the fact that they're not receiving appropriate services. And if it was, everything stops. You cannot expel a student if whatever happened was a what's called a manifestation of their disability, either because the disability directly caused it or an inappropriate placement caused it. The next step is the hearing. The hearing in many districts is heard by an administrative panel. So that could be a principal from one school, a vice principal from another school. They must by law be administrators who are not at the school that the student is from. We had a challenging case where the administrator was from a school next door that had actually been impacted by the incident because, unfortunately, the incident had caused a lockdown, and they had actually locked down both schools. And we argued that she should not be allowed to, or that she was not unbiased on the panel, but unfortunately, the county board did not agree with us. But I still think we were right. So. But it is supposed to be an impartial panel. But of course, keep in mind that impartial is somewhat illusionary in that these are folks that work with people at the school, right? So if you're a principal at one school in a district, you definitely know the principal of the other schools. Even in a larger district, you're likely to know them or at least, have some connections with them. And so that's really important in terms of how you approach the hearing and kind of, I think one of the hardest things in an expulsion hearing is actually tone, especially if you are a litigator and you're used to a very adversarial process. I think in an expulsion hearing, even though it's clearly an adversarial process, you have to be somewhat careful in how you address the panel and how you cross-examine any school witnesses, because they are ultimately all school district employees. And if they feel like you're bullying one of their colleagues, it's not going to go very well. So you can obviously be forceful and get the information you need, but it has to be in a way that is not going to make them feel like you're kind of beating up on one of their staff, because that they are ultimately the ones hearing and making the decision. The decision of the panel goes to the school board. In very small districts, and there are a couple in San Mateo, a couple close by where this happens, they actually just have the school board hear the hearing directly. They don't do the panel. And in larger districts like San Francisco and Oakland, they have kind of a standing panel. So instead of grabbing administrators from different schools, they have people who work at pupil services and that's actually, I think, a little bit tends to be a little bit more impartial. So it kind of depends on which district you're in, exactly what the hearing will look like in terms of who's there. But ultimately the school board has to make the ultimate decision. If there has already been a hearing in front of an administrative panel, when you go to the school board, it's not a new opportunity to present evidence. You can make kind of a last minute plea, basically. You have a right to a timely hearing. A couple things a little trick for remembering timelines. Of course, you can always look them up. But so some timelines in school discipline cases are calendar days and some are school days. And the way to remember which is it's whichever one disadvantages the student. So you have a right to a timely hearing within 30 days, but it's 30 school days. So for those of you who are parents know, with all these random holidays, that could be about 6 weeks depending on the time of year, right? So it's a long time to be out of school. You do have a right to one postponement, the student or parent. And sometimes when you get a case, we've actually already gotten a postponement because we unfortunately have a lot of parents who call us 2 days before the hearing or a day before hearing, and then they agree to ask for a postponement and for us to find them a lawyer. You have a right to notice of the hearing. Guess what? It's 10 calendar days. It's not very many days to get the notice. And you do have a right to have the hearing and documents translated, and a right to impartial decision maker to the extent that you believe that panel is impartial. You have the right to bring representation to the hearing. Actually, under California law, you can either bring an attorney or a non-attorney advocate. So there's not a requirement that if you don't represent yourself, the person be an attorney. And of course, there's no right to counsel. So even though you're welcome to bring someone, it's at your own expense or our pro bono attorney. You do have the right at a hearing to present evidence and to inspect the evidence of the school district. In some districts that haven't seen a lot of lawyers, this is surprising news to them. So you may, if you're in a district that is a smaller district, maybe a little further away from town, you may be the first one who has inspected evidence or presented evidence at a hearing. So that's okay. They'll figure it out. Couple things just to keep, there's some special protections also for foster children, and we have sometimes sent some of these cases to our pro bonos. Under the state law, the attorney, so not the school discipline attorney, but the attorney in the foster care case is supposed to receive notice of the hearing, of the extension suspension, and so sometimes that helps us get these cases when we hear from their juvenile court attorney. So there's kind of different buckets of offenses in terms of expulsions. The first are discretionary offenses. These are the ones that are kind of some of the less serious offenses that you can be expelled for, but it's really up to the principal. And in fact, the education code tells the principal that they for some of these you really should be using kind of looking at other alternatives. So these are some of those, right? So vulgarity and willful defiance, again, is no longer on the expulsion, just for suspension. Medium discretion offenses are offenses that the principal must refer to an expulsion hearing, but it's not required that the student be expelled, right? And so these are some of the ones that you see a lot, right? Physical injury, possession of a knife, possession of marijuana, robbery, assault or battery. So those are pretty common ones that are kind of significant enough that they're always going to get referred to a hearing, but there's not a requirement around what happens at that hearing, basically. There's also a little out in the Ed Code that if the principal determines that expulsion is inappropriate under the circumstances, they could decline to send. And that's important because that's another thing that principals don't seem to know. And so sometimes I've had cases where, it is one of these offenses, but it's a really, really exceptional circumstances, kids who bring a knife to school because they've been, being beat up on the bus for weeks and it's hidden in their backpack and, situations like that. And the principal will say, oh, it's not my fault. Like I had to refer it to the hearing, but that's actually not true. So you can point to that. And they'll say, such a nice kid. I really didn't want to do this. Well, you don't actually have to do it. And then we have what are called the zero tolerance offenses, which are other mandatory expulsions. There's a number of challenges with mandatory expulsion cases. One is that there is no discretion of the principal not to recommend a hearing. The other thing that's really challenging about these cases is they are mandatory, as the expression implies. And so you still have all the procedural rights to a hearing, but if at the end of that hearing it is determined that you have committed one of these offenses, you are going to be expelled regardless of exceptional circumstances. So here they are. They're the big ones. I think there's 6 now. Oh, sorry. No, there's 5. Yeah, so these are the big 5. So notice that drug possession is on the medium, but selling is on the mandatory. Firearm, no matter what, is on the mandatory. Knife possession is medium, but brandishing, and we do have one pro bono who wrote about a 10-page brief about what brandishing is. So, there's room for argument in that in there. But so that brings you up to a mandatory if it's considered brandishing, and then sexual assault and expulsive. Okay, so in a mandatory expulsion, the school still has to prove that they did what they were supposed to do in terms of the evidence and the hearing rights, but and that the student actually committed the offense. But there's no what's called secondary findings, and we'll talk about that in a minute. But what basically what that means is that's it. The school has to prove that you committed one of the mandatory offenses, and then mandatorily you are expelled. But for all other offenses, including the discretionary, including the medium, the school has the burden of proving what we refer to as, so all the same things, but then also what we refer to as secondary findings. And a lot of cases are won right there. Because in all the non-mandatory cases, you have to show that either due to the nature of the act, the presence of the pupil causes continuing danger to physical safety, or that other means of correction are not feasible or have failed in the past to correct the student's behavior. So if you have a case where this is a first offense or there haven't been a lot of other offenses, and you can argue that there really is no threat or continuing threat, and that's a really important it does say continuing danger. We had a huge argument about this in one of our cases where we were making this argument and the school kept going back to how scary it was that day, which nobody was disputing, right? What had happened had created a lot of fears. But actually what a secondary finding is actually about the future, right? It's not about what happened that day. I mean, you have to find that something happened that day, but when you're looking at the secondary findings, you're looking at continued threat. So what happens if the student goes back to school, right? And really this all comes from this core principle that if there's an alternative to expulsion, you should find it, right? Because you don't want kids out of school if there's another way that keeps kids safe, right? So again, this is a really big area. Of course, we have cases that are won with, a pure innocence argument. And then on the other end of the spectrum, we have cases where it's a mandatory expulsion and all we can do is put in all kinds of discretionary factors to have them consider a better placement, and which we can talk about a little bit in a minute. But the bulk of our cases are right here, right, where there's not a huge dispute about what happened, and the question is really whether expulsion is appropriate. Super important, you can be suspended or expelled for things that happen on the way to school, on the way back from school, at a school-related activity, at a football game, at a whatever so that it cannot have nothing to do with school. So if you are at a party on a Saturday night and something happens, that is for police, right? That is not appropriate for school expulsion. But lots of other things that a student will be like, well, I wasn't at school, actually are things that you can be suspended or expelled for. We saw a little uptick in our office in cases when the San Francisco Muni buses put cameras on the buses, and all of a sudden there was a lot more information about what was happening on the way home from school that was not particularly helpful to some of our clients. Okay, so now I'm going to jump into what it actually looks like to have a case. We've kind of gone over the basics in terms of the basic rights that you have in expulsions and types of expulsions. So, and then after that, we'll definitely have plenty of time for questions. So when you get a case, the first thing as I said, is going to happen is you're going to have a conversation with your mentor attorney, and then you're going to set up a meeting with your client. But you're also going to request in writing from the district the expulsion packet, and you have a right to that. That's one of the things that you have a right to, and you see that in the notice that you have the right to the whole packet. Unfortunately, it does not say in the law how much in advance you have a right to have the packet. I always try to say, I just make up a date that I think is reasonable and say, please give it to me by that date. That seems to work relatively well. But it should be reasonable, right? Shouldn't be the day before. And so preferably when you meet with your client, you're going to want to have this packet. I mean, you definitely, at least at one point, going to want to go over the packet with your client. If it's not the first meeting, that's okay. But it's really important to be able to go through it with your client. The expulsion packet generally is going to have a whole bunch of different things. Witness statements, that's really important. They tend to be on these really funny, very school like little forms that say this is what happened with like a little picture, and then so they witness statements can be used, and we'll talk about this in a minute, even if that student is not at the hearing. So they can be used in lieu of someone testifying, with some exceptions. And so, be mindful. These statements are not only a little preview to what you're going to see at the hearing, but they might be in fact all the evidence. There's going to be stuff on discipline history. Discipline history is important. It's unfortunately not completely irrelevant. You can't really argue that it's totally irrelevant because of those secondary findings, right? Because it's relevant to the question of whether other means of correction have been tried, right? So it is going to be in there, and it is going to be relevant. Attendance and grade history, that can be important. I particularly say that it's important if it's not good, you're going to want to counter that in some way at the hearing. Because in general, I think decision makers are less likely to be concerned about excluding a student from school if it doesn't seem like they've been participating fully, right? So if there's a ton of truancy, ton of absence and tardies, that's going to kind of, I would say, reduce the motivation of the panel to look at other alternatives. And so if that is the case, it is important to have your client maybe write a letter about why this was kind of a big moment of learning and how they're really going to do better in terms of attendance, things like that. Or sometimes that information is wrong and you can try to get it corrected before the hearing. So evidence. So expulsion hearings are like a mini trial with no evidence rules whatsoever. So in many ways, I think that makes them a lot of fun and kind of a nice experience. They're kind of fun, particularly for kind of new associates. It's just say, okay, just to try a contested hearing where there's not a lot to worry about in terms of evidence rules. And they will tell you very clearly that the technical rules of evidence do not apply. If you try to get too litigious in the hearing, they will remind you of that. But there are some basic guidelines in the Ed Code. It's supposed to be relevant evidence. So I think if evidence is being put in the packet or testified to that is really just at a pure gossip level, like Sally told Johnny, told Michael that this happened, I think you can argue that that's actually not reasonable evidence and relevant evidence, or certainly that people rely on in conduct of serious affairs, which is what the Ed Code says. Hearsay is admissible. So this is obviously a big problem, right? The vice principal can testify to what a young person said. You can have all these witness statements. However, the decision to expel cannot be based solely on hearsay. So if all you have is a bunch of witness statements and that's it, that's actually not enough. But of course, there's an exception. If the witnesses fear psychological or physical harm, they can have a witness statement that includes that, that they both swear under penalty of perjury to whatever they are writing their statement about, and to the fact that they are fearful of psychological or physical harm if they attend the hearing. And an expulsion can actually be based solely on a witness statement if that is the case. What I see a lot is witness statements that don't have any of that language in them. So if it's just someone who didn't feel like coming to the hearing, that is not something that you could expel a student based on that alone. There is the option in the Ed Code to subpoena witnesses. It's not a great idea most of the time, in that often if your client says, oh, this kid totally saw what happened and I know that he would definitely testify on my behalf, but I don't know how to reach him, or a lot of time you're not going to want to put a high school student up there on the stand before you've been able to talk to them, and if they're not happy about having been brought there. So the only time that I think can occasionally be useful is every once in a while you get a very, very sympathetic staff person who doesn't want to get in trouble and who might say, you know what, I actually love this kid. I think this whole thing was messed up. I really want to testify, but I really don't want to take the heat from my vice principal who wants this kid out. So maybe if you could subpoena me, then I'll, kind of have to go and it won't be my fault. So that's really the only time and when I've found it to be helpful. So again, this is talking about the witness statement, that you can have an expulsion solely based on the hearsay evidence if there is this unreasonable risk of psychological or physical harm. But push back on that. I can't tell you how many times I've been told, oh, they're not here, they're at their violin lesson. That's not psychological or physical harm. So a practical consideration is always whether your client should testify. If there's any kind of parallel juvenile justice proceeding, we really, really advise against it. And also we always connect, if that is happening, we always connect you directly with a public defender or whoever the attorney is for the child in that matter, to make sure that you're being very careful that nothing can be shared or nothing comes out in the hearing that's going to be harmful. Also, if the student hasn't made any statement about the incident and there may not be any non-hearsay evidence, they probably should not make any statement about it at the hearing, because you might be able to actually win the hearing based on a lack of evidence. It doesn't happen that often because, unfortunately, our clients tend to write those witness statements out just like everyone else right after the incident, but sometimes it does. And I have always taken the position that not testifying at the hearing and you know, asserting your right not to testify doesn't mean you can't, you know, read out a letter to the school board about how you want to go to college, right? That's different than not testifying to the incident. And so I really, really highly recommend that any client make some kind of statement during the hearing. And if they're really shy about it or nervous, they could put it in writing, maybe read it, or maybe just ask the board to read it if they really are too nervous to talk. But I do think it's absolutely critical for the decision makers to hear directly from the young person why they want to go back to school. But that's really different than talking about the incident. So who's going to be there? So generally, again, you're going to have this administrative panel, which would be 3 administrative employees. And then you're going to have a hearing administrator. That person is supposed to turn on the tape, turn off the tape, kind of lead things. Say, okay, now it's time for the first witness. Occasionally, those people get a little over-involved. I actually think that's really inappropriate, and we actually recently did an appeal that partly referenced that issue. So I would push back on that. They are not supposed to be asking questions of any of the witnesses, or really, you know, they're supposed to be there to just make sure everything goes smoothly. The representative from the school is usually whoever has the sad job of being in charge of discipline, right? So that's often the vice principal, a dean. Smaller schools, it's a principal, but and often that person is representing themselves, so they are also going to be kind of the lawyer for the school in that case. That is not true in smaller or districts with more money. If there is a lawyer, if one of you shows up, they will also have a lawyer there. That's actually can sometimes be helpful in that then that's someone that you can talk to about settlement. It tends to make the hearing run a little bit more formally, which actually can be very helpful. But in districts like Oakland and San Francisco, they usually just let it happen with the attorney for the student and the principal or vice principal, whoever it is kind of on their own. Witnesses are there, sometimes for the school, sometimes not, really depends on the case. And you can bring witnesses, and you can also bring evidence. And so if you have folks, one thing I always ask our clients at that very first meeting is, who do you have who would support you in this situation? And that person maybe could come to the hearing, but they could also write a letter. And it doesn't have to be someone who knows anything at all about the incident. We're really talking about character witnesses. And they're really important, because what I always tell my clients is the only thing those people up there on the panel know is what's in this packet, right? It's just like a bunch of information about this really bad day you had, right? And so if that's all the information they have, that's not great, right? And so we want to be supplementing with with something from your soccer coach, something from your church, something from your next door neighbor who's elderly and you always help her with her groceries. And, you know, this starts to paint the full picture of who this young person is. And if those people can show up, that's great. But a lot of times that's a lot to ask, and letters are totally fine also. So, and then in terms of just support, it's also totally fine. Obviously, the students' parents have a right to be there. And if there's someone else they want to bring as support, that's totally fine too. The only thing, if that person is going to actually be a witness, then they shouldn't be in the hearing. But if not, if they're just there as a support, sometimes students want to bring their therapist or somebody like that. And so basically an expulsion hearing does follow the format of kind of a mini trial. And so it starts with opening statements, where you can kind of present your theory of the case, you know, whether it's about secondary findings or whatever it is. The school goes first, presents a summary of what happened. That's usually comes from the school witness. If there are witnesses for the school, they're called and can be cross-examined by you. And then this is the weird part that makes it a little different from an ordinary trial, is the panel can ask questions. So imagine like the judge just jumping in and like asking a whole bunch of questions. That's kind of, which I guess occasionally happens, but the panel almost always has some questions for whoever the witnesses are. And then it's time for you to present your case, and you can bring, again, any of your witnesses, and it might include your client, it might not, and it might include some of these other witnesses, possibly another witness to the incident. Sometimes that happens. Sometimes we have other students who are willing to testify. I strongly recommend, if that is the case, that you involve the parents of your client and ask them to reach out to the parents of the student. People do not like getting calls from attorneys, and they really don't like their kid getting calls from attorneys. So I would not reach out directly to a student who might be able to be a witness. I would kind of start with the parents, calling the parents to kind of get that moving. So I'm trying to think. So we have actually a hypothetical, but I think maybe we'll finish the presentation first and see if there are questions, and then see if we have time. I know some people have to go, so I just want to make sure that we're going to go through this. Okay. So, and you can watch this later on your own. There's a little bit more information about this restorative justice program in Oakland in this video. And it's important to know because, again, one of the things, assuming you're making that secondary findings argument, one of the things you're going to want to be able to articulate is, okay, if other means of correction weren't tried, what should have happened, right? What could have been another alternative? And so it's really great if you can talk a little bit or just ask, well, was there any attempt to mediate the situation? Was there any attempt to have the young people sit down together? Do you have any kind of alternatives at your school? Particularly if you're in a district like San Francisco or Oakland, who've actually put a huge amount of work and resources into these programs, you want to know, well, did you just bypass that, right, and go straight to this hearing? So I think that can be really helpful. So these are some other means of correction. So if you're making that argument that other means of correction were not tried, that you're just moving straight to expulsion, that you really can't make that secondary finding, here's some samples of ideas, right? So you can ask, I've done this before, where you just are cross-examining the vice principal and saying, well, did you refer to therapy? Did you refer to anger management? Did you try restorative justice? And just kind of going through it so that by the end it's really clear that they really didn't try anything else.
And I would just add that it's not an exhaustive list, that depending on your client and your client's needs, get creative and see if there are other things that would have been helpful for your client to be able to return to school and correct their behavior, but the school just wasn't willing or did not do anything to try other alternatives.
I think that's a really good point. And sometimes we'll have a parent say, well, I asked them for X, Y, and Z, and they ignored me, right? And so sometimes you even will hear directly from parents some really good ideas that could have really helped. Or this happens a lot in kind of conflict, bullying type of situations. We've had a number of clients who get in trouble because they finally kind of fought back against someone who had been tormenting them. And then you hear from the parent, well, I had 3 different meetings with the school asking for help, right? And so then you can kind of go through that with the school, like, what happened? Why didn't anything happen that could have prevented this? So we're going to also, so we talked a little bit earlier about special education protections. So again, and there's a lot more detail about this in our manual, and it'll always be identified for you if you receive a referral for a young person who is receiving special education, although it is always good to ask a little bit more about just how your client is doing in school. Because students are protected, get that extra step in the expulsion process if they have an IEP, if they have a 504 plan, or if they have unidentified special needs that should have been identified, right? That the school was on constructive notice. So that could be the parent had been asking for assessments, or that there's a clear, the teachers had noticed. So I had a case years ago where I got that expulsion packet that we talked about, and sometimes one of the things in that packet are just little referrals from all the teachers, just saying basically how the kid's doing, are they causing trouble in class, things like that. And so I got one that had one of those. It was a middle school kid, so there was one from 6 different teachers, and every single one said, I don't understand why this child isn't receiving special education services. They're totally suffering. And so we were able to get that expulsion to go away because they really didn't have the right to proceed with it, because they should have known that this child needed to at least be assessed based on what all of the teachers were observing. So you definitely want to still ask about kind of how things are going in terms of school, or have they asked for assessments before, things like that. And you're deemed to have knowledge of special education if you've expressed concern in writing, if they've started an assessment, or the teachers have expressed specific concern. However, if you don't allow your student to be assessed, or you refuse the services, you actually lose that protection. So that's really important, just to encourage parents you're working with, that it's always good to do that assessment. You cannot move forward with an expulsion hearing if it's determined in that kind of pre-expulsion meeting, called a manifestation determination, that the student's behavior was caused by or had a direct substantial relationship to the student's disability, or it was a result of the failure of the school district to implement the student's IEP. So if you have a student, for example, who has been diagnosed as having a pretty significant emotional disability, and they act out in class and throw a chair across the room, you could probably link that pretty clearly to their disability. Or let's say they actually had been, were supposed to be in a much smaller class based on that, but the district didn't have space and they put them in this really big class and they got totally overwhelmed, and that's what happened, then you can link that to an inappropriate placement. And if either of those things are true, then no expulsion goes forward, and you have to look back and try to provide more support for the student with behavior. There are some exceptions in terms of your ability to immediately remove a student for some certain very specific things that are outlined in the federal law. There are just a few of them. It's weapons, drugs, and serious bodily injury, where you could actually remove a student even if it actually was caused by the disability for an interim period. Okay, so just quickly, because I think that sometimes, especially again when there is an attorney involved, you may have the opportunity to settle a case. And this is particularly helpful when you have a client who's just kind of fed up with everything that happened and actually wants to leave the school. And you might be able to arrange a settlement where they do a voluntary transfer, so that's no expulsion, nothing on their record. But then, from the principal's point of view, they got rid of that student, and if that student was having a conflict with another student, that might be a really good alternative. And so there's different other things that you can recommend in terms of possible settlement. Assuming that you go forward for hearing, there's 3 things that can happen. One is that the student is not expelled. That's what you're going for. Under current law, this was changed a couple years ago. If your client is not expelled, they have the absolute right to return to their actual school, not just to another comprehensive school in the district, but the actual school they were at, unless they ask for a different placement. This is relatively new law, and it does appear that some districts are unaware of it, so keep it in mind. The other possible outcome is expulsion. Again, even if a student is expelled, they have the right to an academic program, and they will be given a rehabilitation plan and a date for readmission. Or there is another possibility called a suspended expulsion. This means that technically the student is expelled, but is able to return to either their own high school or another comprehensive high school or middle school during the time. But then if something else happens, then they're immediately expelled and you don't get a new hearing because technically they were already expelled. This is a really good potential outcome if you are dealing with a case with a mandatory expulsion, because there's an attorney general's statement that is in our manual that says this counts. So if it's a mandatory expulsion, if they sold drugs, if something happened that's mandatory, you can do a suspended expulsion and you're still complying with federal law in terms of it being a mandatory expulsion. So this is a really good thing to beg for in those mandatory cases. After the hearing, you have a right to get the decision quickly. If the panel within 3 days, then it goes to the school board. And then you have a right to if you're going to do an appeal, to get the record. They have to transcribe the recording, and they have to do that at no cost to the parents if the parents are low income. And then you have a right to appeal to the County Board of Education. And if you lose at the county board, your final appeal right would be with the Superior Court with a writ. For the county board, it's important to note that you can't appeal to the county board just because you were unhappy with the decision. You have to either be able to argue that there was a procedural violation, or they didn't have sufficient evidence, or they didn't actually make those secondary findings. There's a kind of a list of things you can appeal to the county for, but it's not just that you don't like the way that they found their factual findings, something like that. And then at the end, we have a whole bunch of helpful links. I think we should probably go ahead and jump into questions. I know some people probably have to head out. And then if we have time, if people want to look at the hypotheticals, we can definitely do that. But I know I know some folks probably need to head out. So questions? Yeah.
Probably want to get this. Can we get a copy of that?
Oh yes, absolutely. So after today, you're going to get this emailed to you, and then also one of the links right there is our expulsion manual. So that kind of goes into a lot more detail about the process. Yeah.
You talked about for the discretionary bases that the principal sometimes doesn't realize it's
Mm-hmm.
discretionary. And so I'm just wondering, can the principal retract? And if so, like, what's the mechanism for talking to them?
Yeah, that's a great question. Yeah, I think they can. I mean, it's a little harder once it's already sort of the train has started. In San Francisco, a really good point of advocacy is actually with the Pupil Services Department. So once a principal refers, it goes to this office called Pupil Services. And some districts call it Student Services, but most districts have some office with a somewhat similar name that deals with discipline. And in San Francisco, those folks are actually pretty reasonable. So if a principal referred for something that they really probably didn't have to or maybe shouldn't have, you might be able to advocate with that principal, but you also might just want to advocate directly with the Pupil Services contact, who's the one you're going to be talking to anyway about scheduling a hearing. And sometimes we've occasionally gotten cases dropped completely at that point. And what they'll do sometimes is they'll change the hearing date to what's called a counseling conference and just say, let's get together, let's talk about whether transfer might be helpful or what else could be helpful, but it's not an expulsion hearing. And sometimes we've even found that out like the day of the hearing that, actually, we're not going to make this a hearing. So, but, hopefully you can actually figure out that beforehand. But so that's a really good point of advocacy, especially if there's maybe it shouldn't have even ended up there in the first place.
And I would just add that the district has attorneys, so if there's confusion about the law, then they can check in with their general counsel, right? Like, so that you guys can negotiate some type of settlement if they're wrong on the law. The principal probably won't know that, but the district counsel definitely will.
Yeah, and in districts that get an attorney for the hearing, you should really pretty much just talk with that person. In districts like San Francisco, where they're probably not going to have someone from the hearing, but they're probably consulting, then, I kind of try to leave it up to the Pupil Services people. I always just say, if you'd rather I talk to your attorney, just so that they don't feel kind of harassed by me, but, and sometimes they will and sometimes they won't. So.
And this was largely focused on expulsion, which makes sense, but I'm just wondering if there are opportunities to challenge 1 to 5 day suspension once they happen.
Yeah, I mean, you can, and what's sad is that, the days are lost, right? But you absolutely can. There's not a lot of detail in Ed Code about that, just that every district has to have a process, and the process tends to be like, write a letter to the principal. The good thing is that you can request that it be taken off their record. So, I think for a lot of families, they'll feel like that's, worth it. But yeah, so you can definitely challenge it in that way. It's, there's no way to get the days back, which is what's frustrating about it. But you can get it off your student's record if there was something wrong with the way that they did it.
Once you're moving towards the expulsion hearing, who has the authority, if you're going to cut a deal, to actually, make that compromise with you? And do you have to present that to the panel for approval, or can you kind of settle without going
It
through
kind
that?
of depends. So I've definitely made plenty of deals just with Pupil Services, or maybe sometimes with the assistance of one of the attorney. But there are other times where the attorney will say, okay, I think we have a deal, but I'm going to send it to the board. Mm-hmm. So I think it actually somewhat depends on the district and also whether it's a mandatory recommendation. So I think sometimes the attorney or Pupil Services will feel like, well, this was a mandatory recommendation, the board's going to want to sign off on the settlement. But other times I've just gotten a settlement where they'll drop the whole thing, and so then it doesn't go to the board. So it's not entirely clear. I don't know, Nicole, if you've had other...
No, that's typically how it goes. A lot of the negotiation happens before it gets to the attorney, but ultimately it has to all be approved by the board. So, I mean, if they're negotiating with you, they're like, well, they feel pretty confident then that the board will sign off on it. Right. But at the end of the day, the board is the only entity that has the authority to expel or not. So it
just seems like there's a lot of wiggle room for them to say, I can't cut this deal without the board, and then the board says, well, my hands are tied. This is what, so everybody's kind of blaming each other.
Yeah, it can be definitely tricky to get, because usually your poor client is really stressed out, right? Like, you want to be able to say to them, this is done, right? We've signed it. And often you are waiting for that board approval. I mean, generally, I think once the lawyer has kind of signed off on it, it's pretty likely that the board's going to be okay with it. But
and it's more likely that the attorney or the Pupil Services will say that the school won't sign off on it, right? So if the school is feeling a lot of pressure from the other, student's family or what have you, the employee, then they will want to move forward with the hearing as opposed to them blaming it on the school board necessarily.
Yeah. No, and that's a really good point about there's different reasons. There's certain cases where as long as the school can feel assured that it's not going to happen again, and the kid's getting services, or you can have this very reasonable conversation. And then there's certain situations where you're thinking, why? What is happening here? And usually somebody else is involved, right? Either the other students' parents or the union. We've had a lot of cases of, some fight breaks out and a staff person jumps in the middle of it to break it up, which frankly is not always the greatest plan, and gets hurt, right? And then the expulsion is based on that, and they won't drop it because of that, because the staff person was injured. So there's usually like some other thing going on when you're getting like a really hard time from the attorney about settlement.
I have that exact case right now. My kid, was in a fight, and then the vice principal came up from behind to kind of break it up and got like elbowed in the neck, and now is like going to testify at this hearing, like they're refusing to settle with us. So it's unfortunate, but yeah.
You talked about telling a student not to testify at a given hearing. Is there some provision that gives a student a right not to testify, or?
There's not a specific provision in the ed code, but because pretty much anything you could be expelled for could potentially be something you could be prosecuted for. I've always just exercised that right, and no one's ever pushed back on that. So I think that I think they're not going to force your client to testify. It just can be tricky, right? Because a lot of times it's actually really helpful. And I mean, one thing, and I tell my clients this all the time, one thing that I find is supremely helpful in school expulsion hearings is remorse. And so if your client doesn't testify, it's a little bit harder. They might be able to put it in some kind of, written statement that's not about the incident, but it's hard to show remorse if you don't talk about the incident at all, right? And one thing that I have just noticed is that school administrators, it really makes them mad if they don't feel like the student is sorry at all, right? And sometimes, sometimes there's ways to do that where the student can make a written statement about being sorry about the impact, without talking about very specific things about what happened. But, it is tricky. If your client does testify, I would definitely spend a lot of time prepping them. I have found teenagers to not be the most predictable witnesses, so you definitely want to make sure they feel, fully ready.
Just as a follow-up to that, do you have situations where your advice to the client turns into potential for a future criminal prosecution? Like, I don't want you to testify because you might get asked questions. Yeah.
And in any case that's pretty serious, or where there already has been a police report, we pretty much never let our clients testify. And again, assuming something's been filed, then we'd coordinate with their defense attorney. But yeah, and sometimes that's frustrating for clients because they're like, but I want to tell what happened, and sometimes it's just not a good idea.
So you can get that same testimony or some of that testimony out through their guardian or their parents. I've been very successful in that, and parents are very sympathetic witnesses. So use them to your advantage.
And sometimes a little bit more predictable.
Yeah.
Although not always. So.
Let's talk a little bit more about pre-hearing witness preparation. Obviously, there's
Yeah.
and then you mentioned soliciting witnesses that can be supported either by mother or
Yeah.
To what extent are you actually sitting down with witnesses that are giving opportunities?
Yeah.
How much of that is?
I mean, I think it depends. So if it's like a soccer coach and they're not going to talk at all about the incident and they're just going to say this is a really good kid, then you probably don't need to, take a lot of their time up in preparation. But if it's your client or a friend who's going to talk about the incident, anything like that, I would, definitely do some mock hearing prep just to make sure that you're 100% sure what's going to happen at the hearing and that your client or whoever else is testifying feels really comfortable. One thing that I think, I don't know, Nicole, if you want to jump in, that can be sometimes challenging is prepping parents because it's really hard to testify. It is really powerful, as Nicole was saying, but it's really emotional, right? And parents tend to get really upset. And some parents, I suspect I would be like this myself, tend to defend their child at all costs, right? Which again sometimes backfires, right? Because if you testify about why this is never going to happen again and why you are so sure this was a very isolated incident and et cetera, that's really powerful as a parent. But if you bleed over into it really wasn't that big a deal and it was a big deal, that actually really backfires. So I think it is, I would definitely spend time with parents also. And sometimes just, you can be really honest with them and say, look, like I know that I know that you feel like the district has totally overreacted. I know that you feel like your kid is totally getting a raw deal here. I totally, get how you're feeling that way, but it is important at the hearing that you acknowledge that some harm happened and that there's some desire of your family to kind of, so I think just in the same with clients, just no matter how, you feel like you got, you're the one person getting punished and et cetera, you didn't mean for the teacher to get elbowed, et cetera. It is important to acknowledge that someone got hurt, right? That's going to be really important to the decision makers.
So, is there a difference between the expulsion packet and the student's file?
Yes, you can definitely get both. You should get both. The expulsion packet is just what they're going to use in the hearing. It tends to be about, 10 to 20 pages, not very long. The file will have everything, like their report cards and their attendance, especially if you have concerns about a student, maybe there's a discipline history that seems complicated, or like issues where you're wondering if maybe they should have been assessed for special education. They seem like they're really struggling. It's a really good idea to get the full file. Parents have the right to the full file within 3 days of requesting it. So, so in addition to your procedural right to the expulsion packet, a parent always has the right to the file. It's called the CUME file, which I think stands for cumulative.
And also I've seen panels dig into the CUME file and use some of that in some of their questioning. So it's also good for you to be armed with the same amount of material or information that they may use against your client to describe some pattern of behavior or to talk about different interventions that have tried and failed. So,
but they really shouldn't do that, right? It should. I mean, they're supposed to only be, and so I would definitely object to that if that happens.
So they're limited.
Yeah.
Yeah.
Yes. Although right. Well, right. Because you don't present a packet ahead of time. That's right. One thing that, particularly if there's a lawyer involved, I would request a witness list beforehand. And I would, as a courtesy, also provide a witness list. Because even though the ed code talks about the packet, it actually doesn't say that you have to. So it has happened to me before that I think I know exactly what the witnesses are, and then there's actually a live witness who I didn't know about. And technically, they didn't really have to tell me that because it's not part of the packet. So I would definitely ask ahead of time. Is this the full packet? Just confirming I have everything and who the witnesses will be, and here's who my witnesses will be.
But that's just only an objection later.
Yeah. Yes.
And the substantial evidence standard, is that the same as substantial causation in civil, which basically means it's not very tough?
Yeah, it is not very tough. Yes, yeah. It's definitely, and I think that's that can be really challenging. Also, especially if your client. Sometimes it's confusing for the client if they have a concurrent criminal case, and sometimes that will get totally dropped, and then they're thinking like, why am I still? And the district might say, well, it's a different standard. I do think it helps if the criminal case gets dropped or resolved. I would definitely let the district know that if that happens sort of as, before the hearing. Even though it isn't the same standard, I have found it to be sort of psychologically helpful to be able to say, you know what, this was totally dropped, which happens a lot in, juvenile cases. So. Questions? All right, great. Well, just to, I'll just quickly go back because I think it's somewhat helpful. So the hypothetical, which we can leave with people, but really looks at that, again, where the, I think a lot of these cases are one. And this is this actually comes directly from a case that we had in our office where, as I mentioned, we often get these cases where kids have been sort of tormented and then they crack at some point. In this case, actually, he didn't crack. He didn't lash out against the kid, but he brought a box cutter in his backpack. And this was a young kid too. I think he was in 5th grade. So he was, obviously not making super sophisticated decisions. And he just thought, I'll just feel safer if I bring this. And he didn't show it to the student, the bully. But he did show it to some of his friends and they end up in the principal's office. So this is, I think, a good. So, what arguments would people make in this case? What do you think would be sort of your core theory? So first of all, it's he had this box cutter, but he didn't show it to the person involved. He showed that he had it. So it's not mandatory, exactly. So it's not brandishing, so it's not mandatory. Yeah, and the principal's saying, oh, there's nothing I can do. In fact, that's not true, right? And so if it's not mandatory, then what else would you argue at that point? Do we think that he's a continuing threat? Yeah, I mean, I think. Yeah. So, right. So he obviously did this because he was scared in this particular situation. There's really no evidence that he's sort of ongoing going to be some kind of threat, right? I mean, probably he's going to get a big lecture from his mom about bringing that to school, and, it's hopefully going to be over. And can the school say that other means of corrections have failed?
You can argue that the teacher knows that he's having trouble at home, but no one's put him in counseling.
Yeah, so nothing else has been tried. And he really hasn't gotten in trouble before either. So it's really hard to say like, oh, well, we've tried all these other things and nothing's worked. I think that's important piece too, is that it's not what the code actually says is other means of correction have repeatedly failed. And so, it can't be just, there has to be some pattern of behavior, right, if you're going to find expulsion based on that. And okay, the incident occurred on May 5th. The hearing is scheduled for June 5th. Is it timely? They only get 30 days. Is it timely? Yep. 30 school days, right? They even have some more time if they want. Yeah. Okay. Great. So, yeah.
Sorry,
Yeah, no, go ahead.
What happens if it happens the last day of school?
Oh, yeah. So they do have to do it so there's weird things in the summer where at first they get the 30, but then is it July or August? There's
like 30 more days after the school is over, and the board will still be available to hear the case. But if it's like further into July and August, then it gets.
But yeah, so there's time where basically schools just don't function at all.
So he's in limbo also.
Yeah. So we actually, unfortunately, get a lot of cases towards the end of the year. I think people are just kind of fed up with each other, basically. At that point, we always get like this spike. And so it's always a question of whether to kind of rush it and try to do it in time, which obviously is better for the client not being all stressed out all summer, but can sometimes really rush the case. So sometimes we end up doing those cases so that's the only situation in which you might get a case that you actually had a long time to prepare, is sometimes we do end up waiting till August to do those hearings.
Or also over Christmas break.
Yeah, same thing happens. Yeah. So yeah, it can definitely be even more time based on the breaks. Yeah. All right. So basically, if you're signed up already for our pro bono panel, then you receive emails when we have new cases, and then also the pro bono folks here can send things out. So keep your eye out for new cases. I'm pretty sure we have one this week, at least one, maybe two. Again, once you pick up a case, you'll immediately get a mentor. You'll have a lot more time to kind of talk out the specific strategy in your case, and more time to kind of make yourself familiar with both this PowerPoint and the manual. And you could even read those pages in the ed code because they're very short. But really, I think you can get up to speed very, very quickly. Yes. Yeah.
I know we at least have like a several day turnaround for
Yeah.
So what is the norm?
So basically, in those situations, which is usually what happens, we basically let them know they kind of have a choice. Like usually what we'll say is like, look, I can give you as much preparation as I can on the phone, and you can go without an attorney, or you can get a continuance, and so then usually we have a few more weeks to find an attorney and for that person to prepare. So. Good questions. Yeah. So on our website, there's also a link to sign up for the pro bono panel. Let's see if I can actually get down to it. Oh yes. Oh, I'm sorry. Before you go, make sure to sign the MCLE form. And if you're not from Kirkland, then you can add your name and also put your email so that they can email you the certificate. And if not, okay. Just get it for you. But yeah, if you go to our website, which is the same place where the manual is, oh, here we go. So that's our resource library. But if you go up to let's see, get involved, and it has pro bono panel. And then it tells you there's a little video, one of our pro bono attorneys, but then at the bottom it says online application. And by application, it's like your name and whether you speak a second language, and it's not going to take you a long time. So. And then once you've done that, you'll get a little email saying you've been added, and with the link to the resource library, so you can start looking through stuff. And actually this video is going to go on our resource library too, if you really want to see it again. And then our manual and all those things. And there's samples in our resource library too. There's like sample appeals briefs, stuff like that. So you can just start reading. So. Right, great. Thank you, everyone. Thanks for your interest. Oh, and also just if you have joined our panel and you're just like super excited, this was just very inspiring to you, and you really want a case, let us know. So you can let me know, let folks here know, just to let me know, and we can, even though generally we send things out and it's kind of first come, first serve, if you're just like really eager, or like your trial just settled and you have a bunch of time on your hands, we can always send something directly to you if you're just super excited to start on our case. So, great, thank you.
Thanks.